The winter of 1692 arrives, cold and still across the Massachusetts Bay Colony. Snow lies deep against the meeting house walls in Salem Village, and the frozen ground resists the plow. Inside the parsonage of Reverend Samuel Parris, a fire burns low in the hearth, and two girls sit near the warmth, their bodies moving in ways that no one can explain. You are standing in the doorway of that modest wooden house, watching as 9-year-old Betty Parris and her 11-year-old cousin Abigail Williams contort and cry out. Their limbs twist at odd angles, their voices rise in shrieks, then fall to whispers. Reverend Parris kneels beside his daughter, his face tight with fear, his hands hovering over her trembling body but not quite touching. He does not know what to do. No one does. The room smells of wood smoke and tallow. The floorboards creak under shifting weight. Betty's mother stands against the far wall, her knuckles white against her apron. Abigail rolls onto her side, her eyes wide and unseeing, and speaks words that sound like scripture but are not. The fire pops, the wind presses against the shutters. This is not illness in any form the village has seen before. In the days that follow, other girls begin to show the same afflictions. Anne Putnam Jr., 12 years old, falls into fits in her family's home. Elizabeth Hubbard, a servant girl of 17, complains of invisible hands pinching her flesh. Mercy Lewis, also a servant, cries out that she is being choked by forces she cannot see. The fits spread like frost across glass, slowly at first, then everywhere at once. The village physician, William Griggs, is summoned. He examines the girls with the tools available to him: observation, touch, questions that yield only screams or silence. He finds no fever, no rash, no swelling. Their bodies appear sound, yet they suffer. When pressed for a diagnosis, Dr. Griggs offers the only explanation his world allows. The girls are under the malefic hand of witchcraft. You watch as this word, witchcraft, moves through the village like a living thing. It passes from house to house, from the meeting house to the tavern, from parents to children. It is a word that carries weight in Puritan New England, where the invisible world is understood to press constantly against the visible, where Satan's agents are believed to walk among the faithful, testing and tempting and destroying. The legal framework for responding to witchcraft already exists. English common law, carried across the ocean and adapted to colonial needs, recognizes witchcraft as a capital crime. The Bible itself, in Exodus 22:18, commands, "Thou shalt not suffer a witch to live." The Massachusetts Body of Liberties, adopted in 1641, lists witchcraft among the 12 capital crimes. The law is clear. What remains unclear is who has committed it. Under pressure from the afflicted girls' families, Reverend Parris begins to pray over the children. He fasts. He consults with other ministers in nearby towns. The fits continue. In desperation, a neighbor woman named Mary Sibley suggests an old folk remedy, a witch cake made from rye meal mixed with the afflicted girl's urine, baked and fed to a dog. The belief holds that if witchcraft is at work, the dog will reveal the witch's identity through supernatural means. The cake is made, the dog consumes it, nothing happens. But the act itself, a counter-magic ritual performed within the minister's household, sends shockwaves through the community. Reverend Parris is horrified. He delivers a stern sermon denouncing the witch cake as devilry, as an invitation to the very forces they seek to expel. The village is now caught between two fears, the fear of witchcraft and the fear of what must be done to confront it. You are present when the magistrates, John Hathorne and Jonathan Corwin, are called from Salem town to conduct preliminary examinations. They are not judges in the formal sense, not yet. They are justices of the peace, empowered to investigate crimes and bind over the accused for trial. They arrive on horseback, their dark coats dusted with road mud, their faces set in the grim determination required of men who must look into darkness and name it. The examinations will be held in the Salem Village Meeting House, a simple structure with high windows and hard wooden benches. It is not a courtroom. It has no witness stand, no jury box, no elevated bench, but it will serve. The afflicted girls are brought in. The village crowds the aisles, pressed shoulder to shoulder, breathing the same air, waiting to see what will be revealed. The first names spoken by the afflicted girls are not surprising, not entirely. They name Sarah Good, a beggar woman known for her sharp tongue and her habit of muttering as she moves through the village asking for alms. They name Sarah Osborne, a woman who has not attended church in over a year, who married her indentured servant and lives in a state the community regards as scandal. They name Tituba, Reverend Paris's slave from Barbados, a woman of uncertain origin who has told the girls stories of magic, perhaps, or simply stories from a world beyond Salem's cold certainty. These are women at the margins, women without husbands to protect them, without property to secure them, without the social standing that might shield them from suspicion. Their vulnerability is not legal, not precisely, but it is real. In a theocratic society where godliness and social order are intertwined, to be marginal is to be suspect. The warrants are issued. The constables ride out to bring the accused women to the meeting house. You stand among the crowd as Sarah Good is brought in first. She is unkempt, her clothes worn, her face hardened by years of poverty. Magistrate Hathorne does not ask her to swear an oath. Puritan practice forbids oaths in preliminary examinations to prevent the accused from adding perjury to their sins. Instead, he begins with a question that assumes guilt and demands explanation. Sarah Good, what evil spirit have you familiarity with? None, she answers. Have you made no contract with the devil? No. The magistrate leans forward. Why do you hurt these children? I do not hurt them. I scorn it. At this, the afflicted girls begin to shriek. They point at Sarah Good. They clutch their throats as though being strangled. They fall to the floor, writhing. The meeting house fills with noise, cries, gasps, the scrape of benches as people lean in to see. You watch the magistrate's face. He does not look surprised. He looks confirmed. This is spectral evidence, the testimony of the afflicted that they see the shape, the specter, of the accused tormenting them in invisible form. English law has long debated the admissibility of such evidence. It is intangible, unprovable, immune to cross-examination. Yet it is also, in the Puritan worldview, deeply real. If Satan can send forth a person's shape to do harm, then the testimony of the victim carries weight. The question is not whether the specter exists, the afflicted can see it, but whether the accused sent it forth willingly, in league with the devil. Sarah Good denies everything, but denial, in this room, is expected. The devil is the father of lies. A witch would deny. The magistrate moves to the next question. Sarah Osborne is brought in next. She is older, frailer, visibly ill. She has not left her house much in recent months. When asked why she has not attended meeting, she says she has been unwell. When asked about hurting the children, she says she has not. She suggests, tentatively, that perhaps the devil is deceiving the girls, making them see things that are not there. This is a dangerous answer. It questions the girl's testimony. It suggests that the afflicted, these innocent Puritan children, might be mistaken or manipulated. The magistrate presses her. The girls scream. Sarah Osborne maintains her innocence, but her frailty works against her. She coughs, she sways, she is taken back to custody. Then Tituba is brought forward. The room grows quieter. Tituba is not English, she is not Puritan. She is enslaved, which means she has no legal standing to refuse to testify, no protection under the laws of property or personhood that govern the colony. She stands before the magistrates, and Reverend Paris watches from the side of the room, his face unreadable. Magistrate Hathorne asks the same questions, but Tituba does not deny. She confesses. You hear the words as they leave her mouth, slowly, haltingly, each sentence pulling the room deeper into belief. She says the devil came to her. She says he appeared as a tall man in black clothes, sometimes as a great black dog. She says he told her to serve him, to hurt the children. She says Sarah Good and Sarah Osborne were with her, flying through the night to torment the afflicted. She describes a book, the Devil's Book, in which she saw the names of those who had signed their souls over to Satan. She says there were 9 names, 9 witches in Salem. The magistrates lean in. The crowd leans in. The afflicted girls grow calm, as though Tituba's confession has released them from torment. You watch the faces around you, relief, horror, grim satisfaction. A witch has confessed. The invisible has been made visible. The darkness has been named. Tituba's confession is legally significant. Under English common law, confession is the queen of evidence, the most reliable form of proof. A confession given freely is nearly impossible to overcome. But Tituba is enslaved. The conditions of her freedom, her survival, depend entirely on the will of her master. Whether her confession is free or coerced is a question the law does not require the magistrates to ask. The 3 women are sent to jail in Boston to await trial. The jail is a cold stone structure with narrow cells and iron shackles. There are no windows. The floors are dirt. Sarah Osborne will die there before her trial ever takes place. But the afflictions do not stop. More girls begin to suffer fits. More names are spoken. Martha Corey, a full church member in good standing, is accused. Rebecca Nurse, a 71-year-old woman known for her piety, is accused. The circle widens. The accusations move up the social ladder, touching people who were once thought untouchable. You are standing in the village on a cold March morning when the constables ride out again, warrants in hand. The law is in motion now, and it will not easily be stopped. The machinery of accusation and examination has been set in place, and it operates with a terrible efficiency. Each new examination brings more confessions, more denials, more spectral sightings, more names. The Puritan legal system is built on confession, on the sinner's acknowledgement of guilt and plea for mercy. But it is also built on the principle that the community must be protected from spiritual contamination. If witches walk among them, they must be identified and removed. The safety of the colony depends on it. By the end of March, dozens of people are in custody. The jails in Boston and Salem are filling. The magistrates continue their examinations, but the volume of cases is overwhelming. A formal trial structure is needed, something more than preliminary hearings, something with the authority to convict and impose the ultimate sentence. The legal authority to conduct such trials does not yet exist. Massachusetts is in a state of political transition. The original colonial charter has been revoked by the Crown, and a new one is on its way. In the interim, there is no legal governor, no established court system with the power to try capital cases. The colony exists in a kind of legal limbo, where the old certainties no longer hold, but the new order has not yet arrived. Into this vacuum, the accusations continue to grow. The afflicted girls name more names, the magistrates issue more warrants, the jails overflow. You can feel the pressure building, the sense that something must break, that someone must act, that the law must assert itself or the colony will descend into chaos. In May, the new royal governor, Sir William Phips, arrives from England with the new charter. He is a military man, a former ship's carpenter who rose through colonial ranks. He has fought the French and Indians on the frontier. He is not a theologian, not a legal scholar, but he is the governor, and the crisis is his to solve. One of his first acts is to establish a special court of oyer and terminer, a court empowered to hear and determine cases of witchcraft. The judges are drawn from the colony's elite. Deputy Governor William Stoughton, a Harvard-educated minister turned magistrate, Samuel Sewell, a wealthy merchant, and others of similar standing. They are men of authority, men of God, men who believe absolutely in the reality of witchcraft and the necessity of rooting it out. The trials will begin in June. You stand at the edge of the village green as the news spreads. The law is coming. Not the slow, careful process of common law deliberation, but something faster, something shaped by fear and faith in equal measure. The accused will be brought from their cells. The afflicted will testify. The judges will weigh the evidence, and sentences will be pronounced. The line between examination and execution has been drawn. In the silence between accusation and trial, the village holds its breath. The law has arrived, and it carries with it the weight of certainty, the belief that what is seen must be true, and what is true must be punished. The wheels are turning now, and they will not stop until they have ground through every name, every suspicion, every whisper of darkness in the light. The Court of Oyer and Terminer convenes on June 2, 1692, in Salem town. The courthouse is larger than the village meeting house, but still modest by English standards. Wooden walls, narrow windows, a raised bench for the judges. The room smells of dust and damp wool. Outside, the summer sun beats down on the dirt road, and a crowd gathers, waiting for the doors to open. You are among those who enter when the trial begins. The benches fill quickly. People stand along the walls, pressed close, craning to see. This is not a private proceeding. Puritan law values transparency, the idea that justice must be witnessed by the community it serves. The accused are brought in chains. The afflicted girls sit near the front, their faces pale, their hands folded. The first person to be tried is Bridget Bishop. Bridget Bishop is not marginal in the way Sarah Good was. She is a tavern keeper, a woman who has been married 3 times, a woman known for wearing bright colors and speaking her mind. She has been accused of witchcraft before, years earlier, though those charges were never pursued. Now the accusations return, stronger and more numerous. The trial format follows English common law procedure, adapted for colonial use. There is no defense attorney. Criminal defendants in this era are expected to speak for themselves. There is a jury of 12 men, drawn from the community. The judges sit above, presiding over the proceedings. The prosecution is led by the court itself. The judges are both arbiter and advocate, responsible for questioning witnesses and guiding the jury toward truth. Chief Judge William Stoughton opens the proceedings. He is a stern man, his voice measured and cold. He explains the charge. Bridget Bishop stands accused of witchcraft, of entering into a covenant with Satan, of using supernatural powers to harm her neighbors. The penalty, if convicted, is death by hanging. Bridget Bishop is asked how she pleads. She says she is innocent. She has never seen the devil. She has never signed any book. She has never hurt anyone through witchcraft or any other means. The afflicted girls immediately begin to scream. They clutch their arms as though burned. They point at Bridget Bishop and cry out that her specter is tormenting them even now, in the courtroom, in front of everyone. You watch the judges' faces. They do not look skeptical. They look attentive, as though recording evidence. The prosecution calls its first witnesses. They are not the afflicted girls, not yet. They are neighbors, people who have known Bridget Bishop for years. One by one, they come forward to testify. A man named Samuel Gray says that 14 years ago, Bridget Bishop came into his bedroom at night in spectral form and attacked him, pressing down on his chest until he could not breathe. He says he was awake when it happened, that it was not a dream. He is certain it was her. A woman named Susanna Sheldon says she saw Bridget Bishop's specter in her home, tormenting her, threatening her, demanding that she sign the devil's book. She says the specter wore a black cap and a black coat, even though Bridget Bishop is known for wearing red. Another witness describes finding poppets, small cloth dolls with pins stuck into them, hidden in the walls of a house Bridget Bishop once lived in. The implication is clear. These are tools of malefic magic, physical evidence of witchcraft. The poppets are brought into the courtroom, displayed for the jury to see. You watch the jury. Their faces are grave. In Puritan belief, the devil cannot take the shape of an innocent person without that person's consent. If the afflicted see Bridget Bishop's specter, then Bridget Bishop must have given the devil permission to use her form. This is the theological foundation upon which spectral evidence rests. It is not proof in the scientific sense, but it is proof in the spiritual sense, and for these men, the spiritual is more real than the material. Bridget Bishop attempts to respond. She says she does not know these people, or if she does, she has never harmed them. She says she does not understand what they are talking about. She says she is a Christian, that she prays, that she attends meeting when she can. But her denials sound hollow against the weight of testimony. The courtroom is full of people nodding, murmuring, confirming the accusations with their silence. The afflicted girls are called next. Ann Putnam Jr. takes the stand first. She is 12 years old, small and pale, her voice trembling but clear. She describes how Bridget Bishop's specter came to her in the night, choking her, pinching her, demanding that she serve the devil. She says the specter showed her the book, the devil's book, with names written in red. She says she refused to sign, and for that, the specter tortured her. As Anne speaks, the other afflicted girls begin to cry out. Mercy Lewis falls to the floor, writhing. Abigail Williams screams that Bridget Bishop is biting her, though no one is near her. Elizabeth Hubbard clutches her throat, gasping for air. The courtroom erupts in noise, voices shouting, benches scraping, the judges calling for order. Bridget Bishop stands in the center of it, her face twisted in confusion and fear. She protests that she is not doing anything, that she is standing still, that she does not know why the girls are suffering. But the evidence is visible. The jury can see the girls' distress. They can hear the screams. The judges can see it too. Chief Judge Stoughton leans forward and asks Bridget Bishop to look at the afflicted girls. The moment she turns her gaze toward them, they collapse as one, falling to the ground in convulsions. When she looks away, they recover. This test is repeated several times. Each time, the result is the same. This is called the touch test, and it carries significant legal weight. The belief is that a witch's gaze or touch can harm or heal depending on the witch's intent. If the afflicted recover when the accused touches them, it is because the witch has withdrawn the curse. If they suffer when the witch looks at them, it is because the witch is actively tormenting them. The test is observable, repeatable, and to the Puritan mind, conclusive. The defense, such as it is, rests on Bridget Bishop's continued denials and her appeals to her reputation. She says she has lived in Salem for years, that she has worked hard, that she has never been convicted of a crime. But reputation is a weak shield when spectral evidence is admitted. The law allows the afflicted to testify about what they have seen in the invisible world, and once that testimony is admitted, there is almost no way to refute it. The jury retires to deliberate. They are gone less than an hour. When they return, the foreman stands and delivers the verdict: guilty. Bridget Bishop shows no reaction. Perhaps she expected this. Perhaps she is too exhausted to react. Chief Judge Stoughton pronounces the sentence: Bridget Bishop is to be hanged by the neck until dead. The execution will be carried out on June 10th, 1692, on Gallows Hill. You watch as she is led out of the courtroom in chains. The crowd parts to let her pass. Some people look away. Others stare, their faces hard. The law has spoken. A witch has been convicted. The community is safer now. Bridget Bishop is executed on schedule. She is taken to Gallows Hill, a rocky outcrop on the edge of Salem town. The gallows are simple: a wooden beam, a noose, a cart to carry the condemned. She is allowed to pray. She is allowed to speak. She maintains her innocence to the end. Then the cart is pulled away, and she hangs. She is the first, but she will not be the last. In the weeks that follow, the court of Oyer and Terminer works quickly. More trials are scheduled. More accused are brought from the jails. The procedures remain the same. Spectral evidence is admitted. The afflicted testify. The accused deny. The jury convicts. Sarah Good is tried. She is convicted. Rebecca Nurse, the 71-year-old woman known for her piety, is tried. The jury initially returns a verdict of not guilty. The judges are surprised. Chief Judge Stoughton asks the jury to reconsider, pointing out certain testimony they may have overlooked. The jury deliberates again. This time, they return a guilty verdict. Rebecca Nurse is sentenced to hang. You are present when Rebecca Nurse is brought to the gallows. She is old and frail, barely able to stand. Her family surrounds her, weeping, protesting that she is innocent. She recites the Lord's Prayer without error, a test that witches are believed to be unable to pass, but it does not matter. The sentence has been pronounced. The law must be carried out. On July 19th, 5 people are hanged: Sarah Good, Rebecca Nurse, Susanna Martin, Elizabeth Howe, and Sarah Wilds. They are taken to Gallows Hill together, their hands bound, their faces drawn. A minister attempts to lead them in prayer. Some of the condemned pray with him. Others refuse, maintaining their innocence to the end. Sarah Good's last words are directed at Reverend Nicholas Noyes, who has urged her to confess. She tells him, "You are a liar. I am no more a witch than you are a wizard, and if you take away my life, God will give you blood to drink." The crowd hears this. Some shudder, others harden. The executions proceed. The legal machinery operates with increasing speed. The court of Oyer and Terminer meets throughout the summer. More trials, more convictions, more executions. On August 19th, 5 more people are hanged. John and Elizabeth Proctor, George Burroughs, John Willard, and George Jacobs Sr. George Burroughs is a former minister, a man of education and standing. His trial is particularly significant because he is accused of being the ringleader of the witches, the one who presides over their midnight meetings. The afflicted girls testify that his specter leads them through the air to gatherings in the woods, where they sign the devil's book and plot against the colony. Burroughs maintains his innocence throughout his trial. At the gallows, he recites the Lord's Prayer perfectly, without hesitation or error. This causes some in the crowd to doubt. How can a witch recite the Lord's Prayer? Shouldn't Satan prevent it? The doubt spreads quickly, whispers moving through the crowd like wind through grass. But Chief Judge Stoughton is present, and he addresses the crowd directly. He reminds them that the devil is the great deceiver, that Satan can give his servants the appearance of godliness to confuse the faithful. The execution proceeds. You watch as the bodies are cut down and buried in shallow graves near the gallows. There is no ceremony, no marked stones. Convicted witches are not given Christian burial. Their families are not allowed to claim the bodies. They are erased, removed from both the community and the earth it holds sacred. By the end of August, 19 people have been hanged. Another man, Giles Corey, has been pressed to death under heavy stones for refusing to enter a plea. He died without speaking, without confessing, without giving the court the satisfaction of a trial. His last words, according to witnesses, were, "More weight." The jails remain full. Over 150 people are in custody awaiting trial. The accusations continue. The afflicted girls name more names. The constables write out with more warrants. The system shows no sign of slowing. But something is shifting. Doubts begin to surface, quietly at first, then more openly. Ministers from neighboring towns write letters questioning the use of spectral evidence. They argue that if Satan can take the shape of a guilty person, he might also be able to take the shape of an innocent one. If that is true, then spectral evidence proves nothing. It is merely the devil's tool for sowing confusion and destroying the faithful. In early October, a group of ministers led by Increase Mather publishes a document titled Cases of Conscience Concerning Evil Spirits Personating Men. In it, they argue that spectral evidence is inherently unreliable and should not be admitted in witchcraft trials. The document is carefully worded. It does not accuse the judges of wrongdoing, does not demand the release of the accused, but it does call for caution for a higher standard of proof. The Massachusetts General Court begins to take notice. Governor Phipps, who has been away on military campaigns, returns to find the colony in turmoil. He receives letters from families whose loved ones are in jail, letters from ministers expressing concern, letters from magistrates uncertain how to proceed. The weight of the crisis settles on him. On October 29, 1692, Governor Phipps dissolves the court of Oyer and Terminer. The trials stop. The accused remain in jail, but no new trials are scheduled. The legal machinery grinds to a halt. In January 1693, a new court is established, the Superior Court of Judicature. This court is tasked with clearing the backlog of witchcraft cases, but it operates under different rules. Spectral evidence is no longer admissible as the sole basis for conviction. The judges require tangible evidence, confessions, witness testimony of physical acts, material objects. Under these stricter standards, the convictions stop. Of the remaining 52 accused brought to trial in the new court, only 3 are convicted. Governor Phipps issues reprieves for all three. By May 1693, all remaining accused witches are released from jail. The trials are over, but the damage is done. You stand in the village square on a spring morning, watching as families reunite with those who survived imprisonment. They are thin, pale, marked by months in dark cells without heat or adequate food. Some have lost children who died in jail. Some have lost property seized to pay for their imprisonment. Puritan law required the accused to pay for their own incarceration, including the cost of chains. Sarah Good's daughter, Dorothy, was arrested at the age of 4 and spent months in chains. She will never fully recover. Sarah Osborne died in jail before her trial. Giles Corey was pressed to death. 19 were hanged. The legal process that was meant to protect the community has instead torn it apart. In the months that follow the trial's end, a silence settles over Salem. A silence not of peace, but of exhaustion. The law has run its course, and those who remain are left to count the cost. The dead are buried in unmarked graves. The living carry wounds that will not heal, and the question lingers, unspoken but inescapable. How did we come to this? The new Superior Court of Judicature begins its work in January 1693, but its proceedings are quieter, slower, weighted with caution. The judges are many of the same men who sat on the court of Oyer and Terminer, but the rules have changed. Spectral evidence, the testimony of the afflicted about what they see in the invisible realm, is no longer sufficient for conviction. The prosecution must now present tangible proof, confessions freely given, eyewitness accounts of physical acts, material objects that demonstrate malefic practice. Under this new standard, the cases collapse. You are present in the courtroom when the first case is heard under the new rules. The accused is a woman named Sarah Daston, charged with witchcraft based on the testimony of the afflicted girls. The girls are called to the stand. They describe how Sarah Daston's specter visited them, tormented them, demanded they sign the devil's book. They point at her and scream. They fall into fits. But this time, the judges do not react. Chief Justice William Stoughton watches the afflicted with a different expression. Not skepticism, exactly, but distance. He asks them whether they have seen Sarah Daston do any physical act of witchcraft. Have they seen her conjure spirits with their own eyes? Have they witnessed her harming anyone in the material world? The girls falter. They say they have seen her specter, but they have not seen her in the flesh. They have felt her presence, but they have no physical evidence. The judges confer quietly. Then they instruct the jury. Testimony about spectral apparitions, without corroborating physical evidence, is insufficient to support a conviction. The jury deliberates for less than an hour. The verdict? Not guilty. Sarah Daston is released. The afflicted girls protest, but their voices no longer carry the same weight. The courtroom does not erupt in chaos. The community does not demand the judges reconsider. The energy that drove the earlier trials has dissipated, replaced by something closer to unease. Case after case follows the same pattern. The accusations are the same. The afflicted testify with the same fervor. But without spectral evidence as a foundation, the prosecutions cannot sustain themselves. A few convictions are obtained. In cases where the accused confessed during the earlier proceedings, those confessions are used as evidence. But even these convictions are met with doubt. Governor Phipps reviews each case personally. He issues reprieves for those convicted, commuting their sentences to time served. By spring, all the remaining accused are released from custody. The legal architecture that supported the trials has crumbled. What remains is the question of how it was built in the first place. Spectral evidence is an old problem in English common law. The question of how to treat testimony about invisible supernatural events has troubled jurists for centuries. In 1612, during the Pendle Witch Trials in Lancashire, England, spectral evidence was admitted and used to convict 12 people of witchcraft. In the decades that followed, English legal scholars debated whether such evidence should be admissible. The key theological and legal issue is this: if Satan can take the form of a guilty person to torment victims, can he also take the form of an innocent person? If the answer is yes, then spectral evidence proves nothing. It is merely the devil's deception. If the answer is no, if God would not allow Satan to impersonate the innocent, then spectral evidence is reliable, because the victims are truly seeing the witch's spirit. The Massachusetts trials turned on this question. The judges of the court of Oyer and Terminer believed that God would not allow Satan to impersonate an innocent person. Therefore, when the afflicted saw a specter, they were seeing the true spiritual form of the accused. The fact that the accused might be miles away, in their own home or in a jail cell, was irrelevant. The specter was the witch's agent, sent forth with the witch's consent. But this reasoning created an impossible defense. How can an accused person disprove something that happened in the invisible world? How can they prove they did not send their specter to torment someone while they slept? The accused could offer alibis, character witnesses, evidence of good Christian behavior, but none of it mattered if the afflicted swore they saw the specter. You are present when Increase Mather, one of the most prominent ministers in Massachusetts, addresses a gathering of clergy in Boston. It is late October 1692, and the trials are still ongoing. Mather stands before his colleagues, his face grave, his voice measured. He has written a document titled Cases of Conscience Concerning Evil Spirits Personating Men, and he reads portions of it aloud. "It were better that 10 suspected witches should escape," he says, "than that one innocent person should be condemned." The room is silent. This is a radical statement. The Puritan legal tradition, like English common law, generally favors conviction in cases of serious crime. The safety of the community outweighs the rights of the individual. But Mather is arguing the opposite, that the risk of convicting the innocent is greater than the risk of acquitting the guilty. He continues, "The devil may take the form of an innocent person," he says, "and afflict others in that form. If this is true, then spectral evidence is unreliable. It should not be admitted as the sole basis for conviction." The implications are staggering. If Mather is right, then the entire foundation of the Salem trials is flawed. Every conviction based on spectral evidence is suspect. Every execution may have been a mistake. But Mather is careful not to condemn the judges directly. He praises their intentions, their zeal to protect the colony from Satan's influence. He says they have acted in good faith, under difficult circumstances, with the knowledge available to them. He is not calling for them to be punished or removed. He is simply urging caution going forward. The document is signed by 14 other ministers. It is presented to Governor Phipps, and within weeks, the court of Oyer and Terminer is dissolved. The new legal standard, requiring tangible evidence beyond spectral testimony, reveals how little physical evidence actually existed. The poppets found in Bridget Bishop's house, the testimony of neighbors who claimed to have been harmed years earlier, the confessions extracted under pressure in jail cells from people who believed confession might be their only path to survival. In Puritan legal culture, confession is prized above all other forms of evidence. A confession is understood as the sinner's acknowledgement of guilt before God, a first step toward repentance and redemption. But it is also understood that Satan can compel false confessions, that the devil can twist the mind and tongue to serve his purposes. This creates a paradox. If a person confesses to witchcraft, they might be telling the truth, or they might be deceived by Satan into believing they are a witch when they are not. If they refuse to confess, they might be innocent, or they might be in league with the devil and lying to protect themselves. The law offers no clear way to resolve this paradox. In practice, the resolution comes down to the judgment of the magistrates and the jury. They weigh the confession against the accused's demeanor, their reputation, the testimony of others. They look for consistency, for corroborating details. But in the Salem trials, consistency is elusive. The afflicted describe fantastical gatherings in the woods, flights through the air, meetings with the devil in various forms. The confessed witches confirm these details, but their accounts often contradict each other in small ways. Different locations, different participants, different rituals. These contradictions, which might have cast doubt on the testimony, are instead interpreted as proof of Satan's chaos. The devil is a deceiver. His kingdom is one of confusion and disorder. The fact that the accounts do not perfectly align is taken as evidence of the devil's hand at work. You are in the courtroom when a woman named Mary Easty is brought to trial. She is Rebecca Nurse's sister, and like Rebecca, she is known for her piety and good character. She has been in jail for months. She has maintained her innocence throughout. When the afflicted girls testify against her, she listens quietly, her hands folded, her face calm. Mary Easty does something unusual. She writes a petition to the judges. In it, she does not plead for her own life. She seems to understand that her conviction is inevitable. Instead, she pleads for the court to reconsider its methods, to examine whether the evidence being used is truly reliable. She writes, "I petition to your honors not for my own life, for I know I must die, and my appointed time is set. But if it be possible, no more innocent blood may be shed. I would humbly beg of you that you would examine these afflicted persons strictly and keep them apart some time and see whether they will agree in their stories." The petition is read aloud. The judges listen. Then they set it aside. Mary Easty is convicted based on spectral evidence and the testimony of the afflicted. She is sentenced to hang. On September 22, 1692, she is taken to Gallows Hill along with 7 others. She prays for her judges and for the afflicted girls. She forgives those who have accused her. She maintains her innocence to the end. Then she is hanged. Her petition, however, survives. It circulates among ministers and magistrates. It is one of the documents that contributes to the growing unease about the trials. The question of evidence extends beyond spectral testimony to the reliability of the afflicted themselves. The girls, some of them quite young, exhibit behaviors that are consistent, dramatic, and seemingly beyond their control. But are they truly bewitched, or are they performing? In the 17th century, there is no clear framework for understanding mass hysteria, psychological suggestion, or the influence of social pressure on young people. The concept of hysteria exists, but it is understood as a medical condition affecting women, caused by disturbances of the humors or the womb. It is not understood as a psychological phenomenon that can be socially contagious. Some observers at the time do raise questions. Robert Califf, a Boston merchant, publishes a book titled More Wonders of the Invisible World, in which he criticizes the trials and questions the credibility of the afflicted. He suggests that the girls may be acting out of malice, delusion, or a desire for attention. He points out that their fits stop when the accused confess, but continue when they deny guilt, a pattern that suggests the girls are responding to the outcomes they desire rather than to genuine supernatural torment. Caliph's book is controversial. Many in the community defend the trials, arguing that the afflicted are innocent victims and that questioning their credibility is an attack on the community's children. But Caliph's work adds to the growing chorus of doubt. By the time the Superior Court of Judicature completes its work in May 1693, the legal consensus has shifted. Spectral evidence is no longer considered reliable. The afflicted girl's testimony, without corroborating physical evidence, is insufficient to convict. The new standard is closer to the traditional English common law requirement: 2 witnesses to the same overt act, or a voluntary confession supported by material evidence. Under this standard, none of the Salem cases would have resulted in conviction. You stand in the empty courtroom after the last case is heard. The benches are worn from months of use. The floor is scuffed with the marks of many feet. The air is still. The law has changed, but the dead remain dead. The legal process that convicted 19 people and led to their executions was not an aberration. It followed established procedures. The judges were learned men, educated at Harvard, experienced in English common law. The juries were drawn from the community, ordinary men doing their duty. The witnesses testified under oath. The accused were allowed to speak in their own defense. But the law, applied without skepticism, became an instrument of fear. And fear, once given legal form, is almost impossible to contain. In the quiet after the trials, the community is left to reckon with what the law has done. The evidence that seemed so clear, the screams of the afflicted, the spectral apparitions, the confessions, has been revealed as fragile, unreliable, shaped by belief rather than fact. The law, for all its procedures and solemnity, could not see beyond the fear that drove it. And now the dead lie in unmarked graves, their names erased, their voices silenced. The law has spoken, but it has not spoken truth. The courtroom in Salem town settles into a rhythm through the summer of 1692. Each trial follows the same pattern, the same movements, like a ritual whose steps have been memorized. The accused is brought in chains. The afflicted girls sit near the front, their faces pale in the dim light. The jury takes its place. Chief Justice William Stoughton opens the proceedings with the same formal language, the same questions, and the testimony begins. You are present when John Proctor is brought to trial. He is a farmer, a man in his 60s, known for his direct manner and his skepticism about the accusations. He has spoken openly in the village, saying the afflicted girls are frauds, that they should be whipped for lying. His wife, Elizabeth, was accused first. When he defended her too loudly, he was accused as well. The prosecution calls its witnesses. The afflicted girls testify that John Proctor's specter came to them in the night, choking them, demanding they sign the devil's book. They say his specter bragged about the people he had killed through witchcraft, the children he had harmed. Abigail Williams points at him and screams that he is torturing her at this very moment. She falls to the floor, writhing. John Proctor stands before the judges, his jaw tight, his hands clenched. He calls the girls liars. He says they are performing, that they know exactly what they are doing. He says if the judges would only separate the girls, question them individually, the contradictions in their stories would become clear. Chief Justice Stoughton does not acknowledge the suggestion. He asks Proctor whether he denies the existence of witches. Proctor hesitates. To deny the existence of witches would be to deny Scripture, to place himself outside Puritan orthodoxy. He says he believes witches exist, but these girls are not bewitched. They are deceivers. The distinction does not help him. The judges exchange glances. The jury watches. To accuse the afflicted of lying is to suggest they are in league with the devil themselves. For what innocent Puritan child would fabricate such testimony? The logic is circular, airtight. If the girls are telling the truth, Proctor is a witch. If the girls are lying, they are instruments of Satan, and someone has compelled them to lie. Either way, witchcraft is at work. The role of the accused in these trials is both central and powerless. They are allowed to speak, to question witnesses, to present their own testimony. But they have no attorney to guide them, no legal training to navigate the procedures. They are farmers, servants, merchants, people unschooled in the formal language of law. The judges, by contrast, are fluent in legal rhetoric. They control the questioning. They decide which witnesses to call, which testimony to emphasize, which objections to allow. The trial is not an adversarial contest between equals. It is an examination, a process of discovery conducted by the court itself, with the accused as the subject under scrutiny. You watch as the pattern repeats. The prosecution calls neighbors who describe strange occurrences, livestock dying, children falling ill, milk curdling in the pail. These events, ordinary misfortunes in a farming community, are reinterpreted as evidence of malefic magic. The connection is made through timing. The misfortune occurred after an argument with the accused, or after the accused was seen walking near the property, or after the accused muttered something under their breath. The legal term for this is maleficium, harm caused through supernatural means. Under English common law, maleficium requires proof that the accused performed some physical act, a spell, a curse, the creation of a charm or poppet, and that harm followed. But in Salem, the physical act is often assumed rather than proven. The harm is visible. The accused was present, or their specter was seen. The conclusion follows. The accused must have caused the harm through witchcraft. The accused attempt to offer alternative explanations. The cow died because it was old. The child fell ill because illness is common. The milk curdled because it was a hot day. But these explanations require the jury to accept coincidence over causation, natural misfortune over supernatural malice. And in a world where providence governs all events, where nothing happens without God's permission or Satan's interference, coincidence is not a satisfying answer. The afflicted girls remain the most powerful witnesses. Their testimony is dramatic, immediate, visceral. When they cry out, the courtroom falls silent to hear them. When they collapse, the jury leans forward to see. Their suffering is visible in a way that spectral evidence is not. You can see the contorted limbs, the tears, the trembling. But the nature of their testimony raises questions that the court does not fully address. The girls describe events that only they can see. They speak of invisible tormentors, of specters that fly through the air, of gatherings in the woods attended by dozens of witches. No one else can verify these accounts. There are no other witnesses to the spectral realm. In English common law, testimony is strongest when it is corroborated. Two witnesses to the same event are better than one. Physical evidence that supports testimony is better than testimony alone. But spectral evidence, by its nature, cannot be corroborated except by other afflicted persons who claim to see the same things. The girls corroborate each other, but they are all seeing into the same invisible world. There are no independent witnesses. This creates a closed loop. The girls say they see specters. Other afflicted persons confirm they see the same specters. The court accepts this as corroboration. But if the girls are mistaken, if they are deluded or performing or genuinely experiencing some psychological phenomenon that has nothing to do with witchcraft, then their mutual confirmation proves nothing. Some of the accused try to point this out. They ask the judges, "How can you convict me based on something only these girls can see? How can I defend myself against an accusation that exists in a realm I cannot access?" The judges respond that the invisible world is real, that Satan's kingdom is as tangible as the material world, and that the testimony of the afflicted provides a window into that realm. You are present when George Burroughs, the former minister, testifies in his own defense. He is an educated man, trained at Harvard, fluent in scripture and theology. He understands the legal and theological principles at stake. He speaks carefully, choosing his words with precision. The afflicted girls have testified that Burroughs is the ringleader of the witches, that his specter presides over their midnight gatherings, that he administers the devil's sacrament and recruits new witches into the covenant. These are serious charges, far beyond simple maleficium. If true, Burroughs is not just a witch, but the chief witch, the devil's lieutenant in Massachusetts. Burroughs denies everything. He recites scripture. He explains his theology. He points out inconsistencies in the girls' testimony. They claim he flew them to a gathering on a particular night, but he can prove he was elsewhere. He offers character witnesses, people who have known him for years and can attest to his piety. The prosecution counters by calling witnesses who describe unusual feats of strength. A man testifies that he once saw Burroughs lift a heavy barrel with one hand, something no ordinary man could do. Another witness says Burroughs could lift a musket by inserting his finger into the barrel. Again, a feat of supernatural strength. The implication is clear. Burroughs has made a pact with the devil, and the devil has given him powers beyond natural human capacity. Burroughs attempts to explain. He says he has always been strong, that he has worked hard his entire life, that these feats are exaggerated or misremembered. But the testimony stands, the jury hears it, the judges record it. When Burroughs is convicted, he asks permission to address the court. He says he is innocent, that he has served God faithfully, that his execution will be a grave injustice. Chief Justice Stoughton listens without expression. Then he pronounces the sentence, death by hanging. The confessions present a different kind of testimony, one that seems, on its surface, to corroborate the afflicted girl's accounts. Dozens of people confess to witchcraft during the Salem proceedings. They describe signing the devil's book, attending gatherings in the woods, flying through the air, tormenting their neighbors at Satan's command. But the circumstances of these confessions complicate their reliability. Many are given after weeks or months in jail, under conditions of extreme deprivation. The accused are held in cold, dark cells. They are shackled. They are questioned repeatedly by magistrates who assume their guilt. They are told that confession is the path to mercy, that those who confess may be spared, while those who maintain their innocence will hang. In Puritan theology, confession is also the path to salvation. A witch who confesses, repents, and renounces Satan can be reconciled to God. A witch who refuses to confess dies in sin, damned for eternity. The pressure to confess is therefore both legal and spiritual, not just to save one's life, but to save one's soul. Under these conditions, some people confess to things they did not do. They confess because they believe it is the only way to survive. They confess because they are exhausted, broken, desperate. They confess because they begin to doubt their own memories, to wonder whether they might have done these things without realizing it, under Satan's influence. You are present when Tituba is brought from her cell to testify at another trial. She has been in jail since February, nearly 6 months. She is thin, her voice hoarse. She repeats the confession she gave at her initial examination. The devil came to her, showed her his book, commanded her to serve him. She describes the other witches she saw, the gatherings they attended, the malefic acts they performed together. Her testimony is used to convict others. But Tituba herself is never brought to trial. She remains in jail, forgotten, until someone pays the fees required for her release. She is enslaved, so she has no property of her own, no means to pay. Reverend Paris, her master, refuses to pay. She will remain in jail for over a year after the trial's end, until another person purchases her and pays her jail fees as part of the transaction. The cross-examination of witnesses, such as it is, reveals the limits of the accused's ability to defend themselves. They are not trained in the art of questioning. They do not know how to impeach a witness's credibility, how to expose contradictions, how to frame alternative explanations in legally persuasive terms. When John Proctor questions the afflicted girls, he asks them simple, direct questions. When did you see my specter? What was I wearing? What did I say? The girls' answers are sometimes vague, sometimes inconsistent. But without a legal framework to highlight these inconsistencies, without an attorney to organize the contradictions into a coherent argument, the impact is minimal. The judges do not assist the accused in this process. Their role, as they understand it, is not to advocate for the defense, but to discover the truth. And they believe the truth is being revealed through the testimony of the afflicted, through the physical evidence of harm, through the confessions of the guilty. Some of the accused try to use logic. They point out that if they are in jail, shackled hand and foot, they cannot possibly be sending their specters out to torment anyone. But the theological response is immediate. The devil does not require the witch's physical presence. The specter is a spiritual projection sent forth by the witch's will and Satan's power. Physical restraints are irrelevant. Others try to use scripture. They recite the Lord's Prayer, sing hymns, quote biblical passages. They argue that a true witch could not do these things, that Satan would prevent it. But the judges counter with their own theology. The devil is cunning. He can allow his servants to mimic godliness in order to deceive. The appearance of piety proves nothing. The accused are trapped in a system where every defense can be reinterpreted as further evidence of guilt. Denial is expected from a witch. Confession is proof of witchcraft. Piety is potentially false. Logic is insufficient against spiritual truth. You watch the juries deliberate. They retire to a separate room away from the courtroom and discuss the evidence among themselves. They are ordinary men, farmers, merchants, artisans. They have no legal training. They rely on their own judgment, their understanding of their community, their faith in the judge's guidance. In most cases, deliberation is brief. The evidence seems overwhelming. The afflicted have suffered visibly. The witnesses have testified under oath. The accused have failed to provide convincing alternative explanations. The judges have indicated, through their questions and their rulings, that conviction is appropriate. The jury returns. The foreman stands. The verdict is read, guilty. The pattern repeats, trial after trial, through the long summer months. Guilty, guilty, guilty. The only acquittals come in cases where the evidence is particularly weak, where even the afflicted girl's testimony is inconsistent or half-hearted. But these are rare. By the end of September, the Court of Oyer and Terminer has convicted more than 24 people. 19 have been hanged. Others await execution. The jails hold more than 100 people still awaiting trial. And then, slowly, the machinery begins to cease. The shift begins with the accusations themselves. In the early months, the accused were mostly marginal figures, beggars, social outcasts, people without strong community ties. But as the accusations spread, they began to touch more prominent citizens. Martha Corey, a full church member, Rebecca Nurse, beloved by many, George Burroughs, a minister. Now, in the fall of 1692, the accusations reach even higher. The afflicted girls name Lady Mary Phipps, the wife of Governor William Phipps. They name Margaret Thatcher, the mother-in-law of a prominent judge. The circle has widened too far. Governor Phipps, who has been away from Massachusetts for much of the summer, returns to find his wife accused. He does not allow her case to proceed. He begins asking questions about the trials, about the evidence, about the procedures being used. He consults with ministers, with judges, with anyone who can offer insight. The minister's doubts, which have been growing quietly, now find a receptive audience. Increase Mather's document questioning spectral evidence is presented to the governor. Other ministers add their voices. They do not condemn the trials outright, but they urge caution, restraint, higher standards of proof. The governor listens, and in late October he acts. The Court of Oyer and Terminer is dissolved. The trials stop. In the stillness after the last trial, the community holds its breath. The testimony has been given, the verdicts have been pronounced, the executions have been carried out, but the questions remain, unspoken and heavy. Were the afflicted truly bewitched, or were they deceived? Were the confessions true or coerced? Were the condemned guilty or innocent? The law has done its work, but doubt, once planted, grows like shadow across the land. There are no formal summations in the Salem trials. The Court of Oyer and Terminer does not follow the full adversarial model, where prosecution and defense each present closing arguments to sway the jury. Instead, the judges summarize the evidence, instruct the jury on the law, and send them to deliberate. The accused have no attorney to speak for them, no advocate to weave the scattered threads of their defense into a coherent narrative. But in the months after the trial's end, a different kind of summation begins, a reckoning not in the courtroom, but in pamphlets, sermons, private letters, and public confessions. The community attempts to make sense of what happened, to assign meaning to the deaths, to understand how the law led them here. You are present in January 1693 when the new Superior Court of Judicature begins hearing the remaining witchcraft cases. The atmosphere is different now. The courtroom is quieter. The afflicted girls still testify, but their voices carry less weight. The judges ask different questions, probing for physical evidence, for tangible proof beyond spectral sightings. Chief Justice William Stoughton presides, as he did before, but the other judges are more cautious now. They have read Increase Mather's document. They have heard the doubts whispered in taverns and meeting houses. They know the governor is watching. The first case under the new rules results in acquittal, then another, and another. Of the 52 cases brought before the Superior Court, only 3 result in conviction. and Governor Phipps immediately grants reprieves to all three. By spring, all remaining prisoners are released. The legal process that condemned 19 people to death has been quietly reversed. The law has not changed, not formally. Witchcraft is still a capital crime, but the standards of evidence have shifted, and under those new standards, conviction is nearly impossible. The question of responsibility begins to surface. Who is to blame for the trials? The afflicted girls who made the accusations, the judges who admitted spectral evidence, the juries who convicted, the ministers who provided theological justification, the community which believed and supported the prosecutions. In Puritan culture, blame is a spiritual question as much as a legal one. If the trials were a mistake, they were not merely a human error, but a test from God, or perhaps a deception from Satan. The community must understand which and why and what they are meant to learn from it. Cotton Mather, one of the most prominent ministers in Massachusetts, publishes a book in 1693 titled Wonders of the Invisible World. In it, he defends the trials. He argues that the judges acted properly, that the afflicted were genuinely bewitched, that the executions were necessary to protect the colony from Satan's assault. He presents the trials as a spiritual victory. The community identified the witches, brought them to justice, and thereby preserved the godly order. But Mather's defense is met with criticism. Robert Califf, the Boston merchant, publishes his own account, More Wonders of the Invisible World, in which he questions the credibility of the afflicted, criticizes the use of spectral evidence, and suggests that the judges allowed fear to overcome reason. Califf's book is controversial. Cotton Mather reportedly has it burned in Harvard Yard, but it circulates widely, and its arguments resonate with those who have come to doubt the trials. You stand in a Boston bookshop, watching people purchase both volumes. They read them side by side, weighing the arguments, trying to determine which account is true. The legal process is over, but the intellectual and spiritual process of understanding it has just begun. In 1696, the Massachusetts General Court calls for a day of fasting and prayer, a public acknowledgement that something went wrong. The proclamation does not name the Salem trials specifically, but everyone understands the reference. The colony is called to humble itself before God, to seek forgiveness for whatever sins or errors led to the crisis. On the designated day, you are present in a meeting house in Boston as the congregation gathers. The minister preaches on the theme of humility, on the dangers of certainty, on the need to test one's judgments against Scripture and reason. He does not condemn the judges by name. He does not call the trials a miscarriage of justice. But he speaks of the possibility of error, of the danger of acting too swiftly, of the need for caution when lives are at stake. After the sermon, 12 jurors who served on the Salem trials stand before the congregation. They have prepared a statement, and one of them reads it aloud. The statement acknowledges that they were sadly deluded and mistaken in their verdicts. They express deep regret for the convictions and ask forgiveness from God and from the community. They say they acted in good faith, based on the evidence presented, but they now believe that evidence was insufficient. The statement is carefully worded. It does not accuse the judges of wrongdoing. It does not demand justice for the families of the executed. It simply acknowledges error and asks for forgiveness. In Puritan culture, this is significant. Public confession is a powerful act, a step toward spiritual reconciliation. But the judges do not confess. Chief Justice Stoughton never publicly acknowledges error. He continues to defend the trials for the rest of his life, arguing that the convictions were just and that the dissolution of the court of Oyer and Terminer was a mistake. He believes, until his death, that the colony stopped the trials too soon, that more witches remained undetected, that the community is still at risk. Samuel Sewell, one of the judges who served on the court of Oyer and Terminer, takes a different path. In January 1697, he stands before his congregation in Boston and publicly confesses his role in the trials. He has written a statement, and the minister reads it aloud while Sewell stands with his head bowed. The statement is direct and personal. Sewell acknowledges that he participated in the trials, that he voted for convictions, that he bears responsibility for the deaths of innocent people. He asks forgiveness from God and from those he has wronged. He describes his confession as an act of repentance, a necessary step toward spiritual restoration. You watch the congregation's reaction. Some people weep, others nod in approval. Sewell's confession is rare among public figures of his stature, a wealthy, educated magistrate taking personal responsibility for a public tragedy. It does not undo the harm, but it acknowledges it, which is more than most are willing to do. Sewell's diary, which he keeps for decades, reveals the depth of his regret. He writes repeatedly about the trials, about the nightmares he has, about his fear that he participated in shedding innocent blood. He fasts on the anniversary of the executions. He prays for the families of the executed. The trials haunt him for the rest of his life. The families of the executed seek different forms of justice. They petition the general court for the restoration of their relatives' good names. Under English common law, a person convicted of a capital crime suffers not only execution but also attainder, a legal stain that extends to their family, stripping them of inheritance rights and social standing. The families want this attainder reversed, their loved ones' reputations restored. The petitions are modest in their requests. They do not demand punishment for the judges. They do not seek financial compensation, not at first. They simply ask that the court acknowledge the wrongful convictions and clear their relatives' names. The general court is slow to respond. The political situation is delicate. Many of the judges still hold positions of power. To overturn the convictions is to admit that the legal system failed, that innocent people were executed under the colony's authority. This is not an easy admission for any government to make. But the pressure continues. Year after year, the families petition. They gather support from ministers, from neighbors, from anyone willing to attest to their relatives' good character. They submit documents, testimonies, evidence that was never heard at trial. Finally, in 1702, the General Court passes a resolution declaring that the trials were influenced by the devil and that the convictions were therefore invalid. It is a theological rather than legal framing. The blame is placed on Satan, not on human error, but it achieves the practical goal of reversing the attainders. In 1711, the colony goes further. It passes legislation formally reversing the convictions and authorizing financial compensation to the families. The compensation is modest, £600 to be divided among all the families, but it represents official acknowledgement that the executions were unjust. You are present when the first payments are made. The families come to the courthouse, one by one, to receive their share. Some weep. Others accept the money in silence, their faces hard. No amount of money can restore what was lost, but the acknowledgement matters. The law, which once condemned their loved ones, now admits it was wrong. Not all of the convicted are exonerated in 1711. Some names are omitted from the legislation, either through oversight or because their cases remain controversial. Bridget Bishop, the first to be executed, is not included. Neither is Susanna Martin. Their convictions remain on the books. It will take nearly 3 more centuries for their names to be fully cleared. In 1957, Massachusetts formally exonerates the remaining convicted witches. In 2001, the last of the accused, 5 people who were indicted but never tried, are officially pardoned. The legal process that began in 1692 finally, formally ends in the 21st century. The afflicted girls disappear from the historical record, for the most part. After the trials end, they return to their lives. Some marry, have children, fade into the ordinary rhythms of colonial existence. They do not write memoirs. They do not publicly recant their testimony. They do not explain in any recorded way what they saw or why they said what they said. Ann Putnam Jr., one of the most active accusers, is an exception. In 1706, at the age of 26, she asks to be admitted to full membership in the Salem Village Church. Church membership requires a public confession of faith and, in her case, an acknowledgement of her role in the trials. You are present when Ann Putnam stands before the congregation. A minister reads her statement aloud. In it, she says she was deluded by Satan during the trials, that she made accusations she now believes were false, that she is deeply sorry for the harm she caused. She names Rebecca Nurse specifically, asking forgiveness from Nurse's family. The statement is theologically framed. Anne presents herself as a victim of Satan's deception, not as a willful liar. This allows her to confess error while maintaining that she acted in good faith, that she genuinely believed she was bewitched. Whether this is true, whether she was deluded or performing, or caught in some psychological phenomenon beyond her understanding, the historical record cannot definitively say. The congregation accepts her confession. She is admitted to church membership. She lives quietly until her death in 1716 at the age of 36. She never marries. She leaves no children. Her statement is the only account we have, in her own words, of what she experienced. The legal legacy of the Salem trials extends far beyond Massachusetts. In the decades and centuries that follow, the trials become a cautionary tale about the dangers of spectral evidence, of mass hysteria, of allowing fear to override legal safeguards. English and American legal treatises cite Salem as an example of what happens when courts lower their standards of proof in times of crisis. The trials become a touchstone in debates about the admissibility of evidence, the rights of the accused, the importance of legal representation. In the 18th century, witchcraft prosecutions declined sharply across the English-speaking world. The Salem trials are not the sole cause of this decline, but they contribute to a growing skepticism about spectral evidence and the reliability of accusations based on invisible phenomena. By the 19th century, the trials are remembered primarily as a historical embarrassment, a moment when superstition overcame reason. Nathaniel Hawthorne, descendant of Judge John Hathorne, writes about the trials with a sense of inherited shame, exploring the psychological and moral dimensions of guilt and judgment. In the 20th century, the trials are reinterpreted again as a metaphor for political persecution, for McCarthyism, for any moment when accusations become self-perpetuating and the accused cannot effectively defend themselves. Arthur Miller's play The Crucible uses the Salem trials to comment on the House Un-American Activities Committee hearings, drawing parallels between spectral evidence and unverifiable accusations of communist sympathies. You stand in the present day in a small park in Salem where a memorial has been erected. 20 stone benches, one for each of the executed, bear their names and the dates of their deaths. Visitors come to read the names, to leave flowers, to stand in silence. The memorial is simple, understated. It does not explain the trials in detail. It does not assign blame. It simply records the names and the fact of execution. The stone is cold under your hand. The names are carved deep, meant to last. What the law did in 1692, the law has tried to undo. Convictions reversed, names cleared, compensation paid, public apologies offered. But the dead remain dead, and the questions remain open. Were the afflicted truly bewitched, or were they lying, or were they experiencing something else entirely, something for which 17th century Puritan culture had no vocabulary? The law could not answer that question in 1692. It cannot answer it now. What the law could do, what it eventually did, was admit error, reverse course, and establish safeguards meant to prevent similar errors in the future. Higher standards of evidence, the right to legal representation, skepticism of testimony that cannot be corroborated, the presumption of innocence. These safeguards emerged, in part, from the ashes of Salem. The law learned slowly, painfully, through the deaths of 19 people who protested their innocence to the end. In the years after the trials, silence settles over Salem like snow. The names are spoken less and less. The families rebuild their lives. The judges move on to other cases. The meeting house stands empty on winter mornings, light filtering through the windows, dust hanging in the air. The law has spoken its final word, not in verdicts, but in reversals, not in certainty, but in doubt. And in that doubt, something essential is preserved. The acknowledgement that we can be wrong, that the law can fail, that justice requires not only conviction, but the courage to reconsider. The verdicts, when they came, were swift and certain. Guilty, guilty, guilty. 19 people hanged between June and September 1692. One man pressed to death. Dozens more awaiting trial, crowded into jails from Boston to Salem, their bodies wasting in the dark. But the final verdict, the one that matters most in the long arc of history, is the verdict rendered by time and reflection. The verdict that says, we were wrong. You are standing on Gallows Hill on a summer morning in the present day. The exact location of the executions was lost for centuries, debated by historians, marked by competing theories. In 2016, a team of researchers using historical documents and ground-penetrating radar identified a specific site, a rocky outcrop with a ledge, a place where a cart could pull up and a body could drop. There is no gallows standing now. The hill is covered in scrub grass and small trees. A path leads up from the street below. At the top, a simple marker explains what happened here. You think about the people who were brought to this place in chains. Sarah Good, who cursed the minister from the scaffold. Rebecca Nurse, who prayed for her accusers. George Burroughs, who recited the Lord's Prayer perfectly and caused the crowd to murmur in doubt. John Proctor, who maintained his innocence to the end. Martha Corey, who said she forgave everyone. 19 people, their names now carved in stone, their deaths acknowledged as wrongful. The law executed them. The law, years later, exonerated them. Both verdicts are part of the legal record, but only one can be true. The immediate aftermath of the trials was silence. After the court of Oyer and Terminer was dissolved in October 1692, and after the Superior Court of Judicature cleared the remaining cases in early 1693, the community did not immediately engage in public reckoning. People returned to their farms, their shops, their daily routines. The afflicted girls stopped having fits. The accusations stopped. life went on. But beneath the surface, the trauma persisted. Families were divided. Some had lost loved ones to the gallows. Others had served on the juries that convicted them. Neighbors who had testified against each other now passed on the street in silence. The social fabric of Salem Village was torn, and it would never fully mend. In the years that followed, Salem Village struggled. Crops failed, livestock died, families moved away. Whether these misfortunes were simply the ordinary hardships of colonial life, or whether they reflected deeper social and economic problems exacerbated by the trials, is difficult to say. But the community interpreted them, at least in part, as signs of God's displeasure. Reverend Samuel Parris, in whose household the afflictions first appeared, faced increasing opposition. Many in the village blamed him for the trials, for failing to control the situation in its early stages, for not questioning the afflicted girls more skeptically. In 1696, he was forced to resign his position. He left Salem Village and never returned. The village itself eventually dissolved, reorganizing under a new name, Danvers, as if to distance itself from the events of 1692. The question of what caused the afflictions has been debated for more than 3 centuries. Medical historians have proposed various explanations. Ergot poisoning from contaminated rye, which can cause convulsions and hallucinations. Encephalitis or epilepsy, mass hysteria or conversion disorder. Each theory has evidence to support it, and none can be definitively proven. The Puritans themselves debated the cause. Some believed the afflicted were genuinely bewitched, that Satan had targeted them to test the colony's faith. Others believed they were deluded, suffering from melancholy or some other ailment of the mind. Still others believed they were frauds, performing for attention or out of malice. The legal system in 1692 did not have the tools to investigate these possibilities. There was no forensic medicine, no psychological expertise, no framework for understanding mass psychogenic illness. The only available explanations were theological. Either the afflicted were telling the truth and witches were at work, or they were lying and the devil was using them as instruments of deception. The judges chose to believe the afflicted. That choice led to 19 executions. In 1697, the General Court of Massachusetts passed a resolution establishing a day of fasting and prayer to atone for the trials. The resolution did not explicitly name Salem, but it referenced the late tragedy raised amongst us by Satan and his instruments. This framing, that Satan was the primary actor and humans were merely his instruments, allowed the community to acknowledge error without assigning individual blame. The resolution also hinted at a broader lesson, that all God's people may offer up fervent supplications unto him, that he would pardon all the errors of his servants and people in every kind, whereby they have provoked most justly his holy displeasure to be kindled against this land. The language is careful, collective, not the judges erred, but God's people erred. Not the trials were unjust, but we have provoked God's displeasure. The acknowledgement is there, but it is diffused across the entire community, absorbed into a larger narrative of sin and redemption. For some families, this was not enough. They wanted specific acknowledgement that their loved ones were innocent, that the convictions were wrongful, that the executions were unjust. And so they continued to petition, year after year, seeking not just spiritual reconciliation, but legal vindication. The 1711 Act that reversed the convictions and authorized compensation was titled An Act to Reverse the Attainders of George Burroughs and Others for Witchcraft. It listed 22 names, not all of those executed, but most. It declared that their trials were influenced by the devil and that they had been wrongfully condemned. The financial compensation was distributed based on the perceived social standing of the deceased. The families of Rebecca Nurse and John Proctor received the largest shares. The families of others received smaller amounts. Some families received nothing, either because they did not petition or because their petitions were denied. The act also included language expressing the general court's deep sense of the sufferings of those persons and their desire to make some amends for the wrongs done. It was an admission of error, but it was also a pragmatic political compromise, enough to satisfy the petitioners without unduly embarrassing the judges who had presided over the trials, many of whom still held positions of power. You imagine the families receiving their compensation. Some would have welcomed it as a measure of justice. Others might have resented it. No amount of money could restore a mother, a father, a spouse. But it represented something important, official acknowledgement that the law had failed. The legacy of Salem extends into the structure of American law. The trials are cited as one reason the Sixth Amendment to the U.S. Constitution guarantees the right to legal representation in criminal cases. The idea that an accused person should face the power of the state alone, without an advocate, is now understood as fundamentally unjust. The trials also influenced the development of evidentiary rules. The prohibition on hearsay, the requirement for corroboration, the skepticism of testimony about invisible or unverifiable phenomena, all of these principles are, in part, reactions to the failures of Salem. The phrase spectral evidence has entered legal and cultural vocabulary as shorthand for unreliable testimony, for accusations that cannot be tested or refuted, for the danger of convicting based on fear rather than fact. In this sense, the trials have served a purpose. They stand as a reminder of what happens when legal safeguards are removed, when the pressure for convictions overrides the presumption of innocence, when courts prioritize the community's fear over the individual's rights. But the trials also resist easy lessons. They were not the result of a single villain or a single error. They were the product of a complex intersection of theology, law, social tension, and genuine human suffering. The judges were not monsters. They were educated, devout men trying to protect their community from what they genuinely believed was a satanic threat. The afflicted girls were not simply liars. They exhibited real distress, whether caused by illness, psychological trauma, social pressure, or something else. The community members who testified against their neighbors were not acting out of pure malice. Many believed they were telling the truth, reporting real experiences, helping to identify genuine threats. The juries who convicted were not bloodthirsty. They were ordinary people doing their civic duty, weighing the evidence presented, trusting the judges to guide them. And yet, 19 people died. Dozens more suffered imprisonment, loss of property, loss of reputation. Families were destroyed. The social fabric was torn. The question the trials pose is not simply, how could this happen, but how do we prevent it from happening again? And the answer is not comforting, because the answer is constant vigilance. Skepticism of claims that cannot be verified, insistence on high standards of proof, protection of the rights of the accused, even when, especially when, the community demands conviction. willingness to admit error and reverse course. These safeguards are not natural. They must be built, maintained, defended. And even with them in place, the law can still fail. But without them, failure is certain. You stand in the Salem Witch Trials memorial on a quiet afternoon. The stone benches are cold in the November air. Leaves scatter across the ground. 20 names, 20 lives, 20 stories reduced to dates and accusations. The memorial was dedicated in 1992 on the 300th anniversary of the trials. Nobel laureate Elie Wiesel spoke at the dedication. He drew connections between Salem and other moments of mass injustice, other times when fear overcame reason, when communities turned against their own members, when the law became an instrument of oppression rather than justice. The memorial does not explain why the trials happened. It does not assign blame. It simply records the names and allows visitors to remember. In that act of remembering, there is a kind of justice, not the justice of compensation or exoneration, but the justice of acknowledgement. These people lived. They died unjustly. We remember them. The final legal chapter of the Salem Witch Trials did not close until 2001, more than 3 centuries after the executions. That year, the Massachusetts governor signed legislation formally exonerating the last 5 people who had been indicted but never tried. Their names were cleared from the legal record. The process begun in 1692 was, finally, complete. But history does not offer clean endings. The people who died are still dead. The families who suffered still suffered. The social and psychological wounds do not heal simply because the law acknowledges them. What remains is the story, the legal archive, the record of what happened when fear met law, when invisible accusations became capital convictions, when a community's certainty led to tragedy. You walk slowly through the memorial, reading each name: Sarah Good, Rebecca Nurse, George Burroughs, John Proctor, Bridget Bishop, Giles Corey, Martha Corey, Mary Easty, Susanna Martin, Elizabeth Howe, Sarah Wilds, George Jacobs Sr., John Willard, Ann Pudiator, Alice Parker, Wilmot Redd, Margaret Scott, Samuel Wardwell, Mary Parker. 19 hanged, 1 pressed, all innocent in the eyes of the law, 3 centuries too late. The wind moves through the trees. The stones stand silent. The law has rendered its final verdict, and in that verdict there is both sorrow and warning. This happened. It could happen again, unless we remember, unless we learn, unless we insist that the law serve justice, not fear. The trials are over, but the story endures. It lives in legal textbooks, in history classes, in memorials and monuments. It lives in the questions we ask about evidence, about rights, about the proper balance between community safety and individual liberty. And it lives in the names carved in stone, in the memory of those who stood before judges and said, "I am innocent," and were not believed. The law failed them. The law eventually acknowledged that failure. But the dead do not return. And the lesson, hard-won and dearly bought, is this: the law must serve truth, not certainty, justice, not fear. And when it fails, as it will, because it is human, it must be willing to say so, to reverse course, to remember. The archive remains, the names endure, and we, the living, bear the responsibility to learn from them. Asterisk.